There are essentially 4 steps to analyze whether an innovative concept is patentable. They are novelty, inventive step, and the requirement that the invention be susceptible of industrial application. And then a 4th step is to make sure that the invention is not excluded by a statutory or treaty-based exclusion. And that may involve an assessment as to whether the invention has a technical character in the European Patent Convention territory. Here in the United States, we have a little bit different approach. We mostly use different names, but usually we end up with something like the same result. We know from the reading that novelty is determined in the light of the state of the art as of the priority date. It's a worldwide standard. A disclosure that would destroy novelty in Russia will also destroy novelty in the United Kingdom. There are no boundaries when it comes to determining prior art. And the standard is one of absolute novelty. Let's use the patent terminology anticipating disclosure, that is, one that would destroy novelty that occurs prior to this priority date, which is the date of initial filing, will destroy novelty. Even just the day before you file the patent application, if a publication comes out that discloses how to make your invention, then except in unusual circumstances, you're not going to be able to obtain a patent because the invention will not be considered novel. There is, as noted here on the screen, a 6-month grace period if there's been an enabling disclosure prior to the filing of the application, and that disclosure has been in breach of an obligation of confidence. There's a case that is cited, it's a decision of the IPO, Intellectual Property Office, called three-way pressings. It's cited in the notes, which gives you actually a very good example of the application of that 6-month grace period where there's been a disclosure in breach of an obligation of confidence. When we talk about anticipating an invention, that means that there is enough disclosed publicly prior to the priority date that it destroys the novelty and prevents the patenting. In order for that to be the case, the prior art disclosure must be an enabling disclosure. And you will have seen in the reading some references to this. Anybody want to volunteer to say what an enabling disclosure refers to?
I mean, I can jump in just very briefly and say my understanding is that it essentially, Dougal here, it relates to kind of a disclosure that's sufficient to enable someone that is skilled in the art to, to understand the process and the invention and put it into practice, so to speak.
That's exactly right. And if anybody got a look at the transcript of yesterday's text chat, we went into this in a little bit of detail yesterday, what it means to be an enabling disclosure. This is actually a concept that shows up twice in the patent analysis. It shows up once in determining whether a prior disclosure anticipates an invention and makes it not novel and thus not capable of being patented. It also shows up as a requirement in the patent application. In the application, you have to disclose how to make the invention. The reason for the enabling disclosure requirement in the patent application is the patent process involves what many theorists call a bargain for exchange or a quid pro quo, meaning that the patent applicant or inventor is given these exclusive rights, a form of monopoly, in exchange for something. We don't just give that to people and not expect something back. So they get this temporary monopoly, which lasts for how long?
20 years.
That's right, 20 years from the priority date. And in return, the inventor is required to disclose publicly how to make the invention. Both sides benefit. The inventor gets the exclusive rights, which enable him to make an economic profit. And society gets an increase in the amount of knowledge, of technical knowledge about how to create useful technology. It's a subject that actually comes up quite a lot in revocation proceedings. After a patent has been issued, the question comes up, did the patent application in its specification properly describe how to make the invention? Did it make an enabling disclosure? I'm a little more familiar with patent law here in the United States. Over here, it is not infrequent that you find that patents are revoked because they did not contain an enabling disclosure. The patent applicant is going to try to disclose as little as possible, just the bare minimum necessary to get the patent while retaining the rest of the know-how, the technical knowledge, in-house and secret so as to maintain that competitive advantage. But there is a risk in doing that, in that you may find that you don't get a patent at all, or if you do get a patent, it's invalidated.
Sean, I had a question, Dougal here. I just wondered is there a risk that if you, in the disclosure only do the bare bones to try and kind of protect the intricacies of it, that you then are exposed to someone else essentially trying to register an additional inventive step that might have actually been included in your enabling disclosure, but you didn't actually, capture it in the patent, so to speak?
There's a distinction to be made between the different parts of the patent, because the enabling disclosure is made in what's called the specification or the description of the invention. Then the actual definition of the patent monopoly, what's claimed as subject to the exclusive rights, is contained in the claims themselves. Usually the patent lawyers are very savvy about writing very expansive claims. To the best of their ability, they try to prevent people from, as they say, inventing around the claimed invention. But there is a danger if you have a very expansive claim and a very narrow enabling disclosure, because the courts or the UK IPO can look at this and say the claims are not adequately supported by the enabling disclosure, and therefore either the claim is stricken or the entire patent is not awarded or it's invalidated after issuance.
Actually, I don't understand exactly the meaning, the difference between the disclosure and enablement, because if I'm right, reading the textbook, I saw that speaking for disclosure, we mean that the person skilled in the art must have the information needed in order to proceed without any further experiments and to work on the invention. And so if on the one hand we have the information which is needed, and on the other hand the enablement is the ability to proceed with the invention. So what's exactly the difference between the two?
It's probably not a good idea to try to separate the concepts of enablement and disclosure. It's possible to just in the description say, give a very brief, step-by-step statement, this is how you would do it, and leave out some critical information. Well, you've made a disclosure of a sort, but you haven't enabled someone through that disclosure to make the invention.
Mm-hmm. Yes, okay, thank you.
Sean, it's Lily here. I just want to double check. So is my understanding correct in that you need, I know you said not to split the elements of disclosure and enablement, but do you need both?
I've discussed the use of the enabling disclosure concept in two contexts. The first was relating to the novelty determination, and the second was relating to what has to be in the patent application. When you're looking at novelty, the ultimate question is this invention new? And the question of an enabling disclosure comes up where you found a bit of prior art. If we look at the exam for last year, there was a question that related to the development of a drug for arthritis. There had been a physician in Bosnia-Herzegovina who developed the basic idea for the invention back maybe 20 years previously and had written it up in a very obscure newsletter. He was killed in the war, and most copies of the newsletter were gone, and there were maybe just a handful of copies of the newsletter still in existence, deep in archives and in doctors' files. The novelty question presented there, you would go through the whole analysis, but one of the obvious first ones is, Was it prior to the filing date or the priority date? And the answer in that case was yes. Does the fact that it was published in the Serbo-Croatian language and published in a relatively small area outside the UK, the fact that it's published in another country is irrelevant because we're dealing with a worldwide standard of novelty. The hypothetical question on an exam did not get into the details of what was disclosed in that newsletter. But if you were looking at this as a patent examiner or looking at it on re-examination, you would have to have a copy of the newsletter and say, okay, what is actually disclosed here? Did it just refer to a technique that the doctor had developed without really explaining how to use it, to implement it? Or was it sufficient to enable another doctor or someone working in the field to go back and replicate what he had done? If it's the latter, it's an enabling disclosure and it would destroy novelty. But if it's just a general description that wouldn't by itself enable you to recreate the invention, then it doesn't affect novelty.
Yeah, that certainly helps. So essentially, in order to determine if something's been anticipated, the invention, both elements of prior disclosure and enablement would need to be satisfied, because you would only consider enablement if there's been a prior disclosure.
That's right.
Okay, that makes sense. Thank you.
It's complicated. I should say that there's a great deal of detail that you can go into, that the practitioners go into, that is really beyond the scope of this course. There was one more thing I would say about the novelty requirement before moving to the next subject. In the case of the exam from last year, the Serbo-Croatian newsletter is the prior art reference, the main one that we're interested in. In doing the novelty analysis, you do not combine prior art references unless they specifically direct you to another prior art reference. Say that the Serbo-Croatian newsletter reveals only half of the way to develop the invention, and then there's another publication in the British medical journal Lancet which describes the other half. Well, unless there's an explicit reference between those two publications, for example, the Lancet paper saying, see this Serbo-Croatian newsletter from 1992, then in doing the novelty analysis, you don't put those two things together and say, well, half of it's disclosed in one article and half of it is disclosed in another, and therefore it's not novel. That's not the way novelty works. The enabling disclosure and the entirety of the enabling disclosure has to appear within the four corners of the document or other disclosure. That does not mean that inventors don't have to worry about finding bits of the description in different places, but that is an inquiry that's left for the inventive step stage. You can combine prior art references if it would have been obvious to a person skilled in the art to do that at the inventive step stage, but you don't do that for purposes of novelty.
Wouldn't that be a bit unjust, for example, for someone to take advantage of a document published in Bosnian, as you said, and then having access in another document in the UK or elsewhere, to combine those two and to present an invention as his own, whereas this, well, in my view, it wouldn't be fair enough, actually.
The question is a question of inventorship, which is a little bit different from the novelty issue. Were you involved in the conception and reduction to practice of the invention? And in the case you described, if he just takes two documents and combines them, there is an inventive element in the combining if it wouldn't have been obvious to the regular person skilled in the art to put those two pieces together. There is a contribution, but the scope of what you could patent in that situation it's probably not everything that is disclosed in each document, because those are part of the prior art. Why don't we go to inventive step now? The inventive step process, this is what in the United States we call the obviousness inquiry, and it is very much the same here in the U.S. in the UK and in the European Patent Convention territory. And the basic idea is that the invention would not have been obvious to a person skilled in the art. And what's the memorable term that one of the UK justices used to describe the person skilled in the art? In the notes, you'll see that one of, I think it's Lord Denning in the UK, referred to the person skilled in the art as a person who is competent, who has knowledge in the field, specialized knowledge even, but is utterly uninventive, uncreative, and, as he put it, a nerd, which I'm still not sure actually fits, is the best description, but it's something that I can't quite get out of my memory now. So what does it mean to be obvious? I have here on the second bullet a quote from the EPO patent guidelines. Obviousness means that the invention or the concept doesn't go beyond the normal progress of technology, but merely follows plainly or logically from the prior art. In any given case, that may or may not be helpful, but the idea is not that you have to be a genius. And actually in the United States, for a period up until 1952, there was a judicially created requirement that to pass the obviousness or inventive step requirement, you had to show that there was a flash of genius in the inventive concept, something really extraordinary. The U.S. Congress rejected that requirement in 1952, but it's never been a part of the UK patenting criteria that you have to have this truly Einstein-like discovery or inventive concept. If the innovation is more than what you would normally logically expect to flow from what the prior art discloses, then you can get a patent. This Pozzoli case, the idea is first you identify, well, what is the person skilled in the art? Who would this be? What is the field of the art? If we go to the exam question that I was referring to yesterday, the field is going to be, we're talking about a drug to treat arthritis. It's going to be a field like rheumatology, maybe biochemistry, something of that nature. It's not going to be computer engineering. Part of identifying the person skilled in the art is identifying the field and then determining what is this person skilled in the art, what would that person be expected to understand and know. And that's part of the second bullet is the relevant common general knowledge that that person would have. Once you've done that, you've established the standard by which the inventiveness or non-obviousness of the invention will be determined. Then you look at the claims of the patent and say, or the patent application and say, what is the inventive concept here that is really being sought to be patented? What is the new thing? The next step is, once you've identified that inventive step, you compare that with the existing state of the art, all that prior art that exists before the priority date. This is, I think, a very subjective process, not something that can be really rendered mathematically objective. You look at all of the evidence and determine, would that person skilled in the art who has that common general knowledge have found it obvious to identify that inventive concept? And if so, if it would have been obvious, then it fails the inventive step requirement and you don't get a patent. If it would not have been obvious, then you pass the inventive step requirement. It should be mentioned, I think this final bullet is a little out of context, but the fictional skilled addressee, that means the person skilled in the art can actually be a skilled team of people, so that if the invention covers multiple disciplines, you would have the nerd team, totally unimaginative but technically competent and knowledgeable people in those different fields, and they would form a collective person skilled in the art by which you would judge whether the invention was obvious.
I was just going to say, it's Dougal here, I've always found this step, or just from the readings really, found this step sit somewhat, I don't know, I'm slightly uncomfortable with it to the extent that I think it's quite hard to objectively and retrospectively evaluate what would be obvious to anyone, or even a skilled person or anyone. Plenty of inventions, I think, seem obvious after they've been thought up with, or steps, they seem like, oh, I could have thought of that, but actually it is, having the idea and putting it into effect that is the distinction. I guess. But I guess you have to evaluate on inventiveness in some way. So
That's definitely true, and it's easy to become very, I think, cynical about the whole endeavor because it sounds a lot like post hoc rationalization, but there are some patent doctrines that try to eliminate some of the effect of looking at things in hindsight. At least in the United States, one of the things in determining obviousness is the fact that no one had ever previously come up with a similar solution to the problem that the invention addresses is a clue or evidence that it is inventive. There are multiple case law developed doctrines that try to filter out some of the subjectiveness of this inquiry.
It's Lily here. Just to, I think I agree with Dougal on that. To add to that, to say that by being able to get a pool of persons skilled in the art by drawing on experts, that really widens the scope of that point, and then obviousness could actually become satisfied quite easily when if you were to consider a pool of experts as part of this sort of step.
It seems a little unfair, but that is the standard, and somehow, despite this standard, which is, we have the same standard in the United States, somehow despite this we still get patents for yo-yos and mousetraps and things that you would think all of the inventive steps possible had been squeezed out of a concept. But the patent examiners, I think, are sensitive to the fact that they shouldn't be engaging in too much of the hindsight judgment of whether something was obvious or not, because it's just too easy. So I think it's possible that by attempting to compensate for that hindsight bias, maybe sometimes the patent examiners bend a little too far backwards to try to be fair to the inventors. And at this point, I think it's probably useful to just open up the discussion to anything that anybody wants to raise.
Hi, Sean, it's Nicola here.
Hi.
Just going back to a point that was made earlier on the enabling disclosures, I may have just been misconstruing what was said, but my understanding from the reading is they are, when assessing novelty, very distinct concepts, and you could apply both to the same piece or the same disclosure and you may come out with a different result, and both need to be passed in order for it to be considered an enabling disclosure. What seemed to be suggested was that they are in some way linked, and that if you fail the disclosure element of it, then it really couldn't be considered to be enabling. Am I misunderstanding what was said earlier?
You're referring to the assessment of novelty and at the point of determining whether an invention is patentable. Is that right?
No, that's correct, yeah.
Okay, because it's an entirely separate inquiry from what has to be in the patent application.
Mm-hmm.
The inventor, in filing a patent application, is going to hope that the prior art that's already out there does not contain an enabling disclosure, because if it does, that's what destroys novelty. In the novelty context, the enabling disclosure doctrine is fairly protective of the inventor and his rights, because it says, unless the four corners of this document or disclosure, which can also be oral or in other media, unless the four corners of this disclosure tell you how to make the invention, then you don't have to worry about it for purposes of novelty. That is an inquiry that you would have to make when looking at prior art in the novelty determination. It is separate from the determination of novelty with regard to whether the patent application gives you a sufficient disclosure. And in that case, it's you, the inventor, who are telling the world, this is how you make the invention. And it has to be sufficiently complete and detailed to enable a person skilled in the art to reproduce the invention.
It seems then really that the assessment, or to pass the enabling disclosure assessment, is probably slightly less stringent on the inventor than the onus being on them to prove that their invention is capable of being made on the basis of what they've disclosed in their application. Is that?
The idea in the British case law is that the standard of what is enabling is the same for both inquiries, but those inquiries are made at different stages, and the consequences of there being enabling disclosure in the novelty context are you don't get a patent. The consequences of having an enabling disclosure in the patent application is that if it does make an enabling disclosure, then provided everything else is satisfied, then you do get a patent.
No, that makes sense. Thank you.
Sean,
Sean, sorry, go for it, Curtis.
Go on, sorry.
Oh, sorry for butting in. All I was going to say was that I'd read the, the part of the notes in relation to computer programs, and I kind of understood the flow of what you were talking about in relation to the inconsistency between the English courts and the EPO. But I was just interested in if you could sort of not summarize, but just give an indication of where you think things are heading in terms of patentability of software and kind of computer programs in general, because it seems to me, there's instinctively I feel like there should be some level of patent protection to a lot of software, and I just wondered whether things were heading that way, or whether which way the tide was going, basically.
It is a big issue in the UK, in the European Patent Convention territory, and around the world, the extent to which software is patentable. And you have to remember that in the UK and under the European Patent Convention, it's not anything that has something to do with software that is excluded from patentability, but only computer programs as such. And that is common ground, obviously, between the UK and the European Patent Office. In the United States, we don't have an explicit exclusion of computer programs. There's a 1980 decision of our Supreme Court that says anything under the sun invented by man is patentable. That turns out to be an overstatement, but the point of that is not all countries have this explicit kind of exclusion from patentability that the UK and the European Patent Convention. The UK tried initially very religiously to follow the rulings of the European Patent Office boards as to when computer implemented invention or software implemented invention can be patented. It ended up feeling fairly confident that a definitive test had been developed in the Vicom case, looking at whether the invention has a technical character. Since then, it's the perception of the British courts that the European Patent Office has varied in its approach. It hasn't consistently applied the same test from one case to another as to whether a computer program or a software implemented invention can be patented. And so, at least as characterized by the British courts, there is this sense that in the EPO, they've taken the position that if there's software involved in invention, the presence of almost any hardware is sufficient to take it out of this exclusion for computer programs as such. In other words, the presence of any hardware enables you to treat an invention that has a software component just like any other invention, and you don't have to worry about the computer program exclusion. The European Patent Office says, no, we've been consistent. There is a basic difference between how civil law jurisdictions approach precedents and the UK does. And the UK courts have said we are bound by our prior precedent at least until we feel that the European Patent Office has come down with a firm, consistent approach to applying this exclusion. So that, I think, is where things stand for the present. And as for the future, I think that you're right. It is something that we're going to continue to struggle with around the world, whether there's an exclusion or not. I mentioned earlier the United States doesn't have an express exclusion for computer programs in its Patents Act, but the courts in the United States are facing a very, very similar question about how abstract does an invention have to be before you say it's not patentable. And we do have the judicially created doctrine here that abstract ideas, purely mathematical equations and laws of nature are not patentable. That judicially created doctrine has ended up being applied in some ways very similar to the way that the UK courts and the European Patent Office is applying the computer programs as such exclusion. We don't end up with identical results. I think it's still fair to say that the U.S. has a more permissive approach to patenting of software per se. It's an extremely murky area, and there's a recent case, Alice versus CLS Bank, a U.S. Supreme Court decision which invalidated a software-related invention patent on the ground. It really was an abstract idea. The patent bar, at least the patent bar in the United States that deals with software inventions sank into deep despair over that because they said, we don't know what this means. What's abstract and what isn't? I think it's an inherently difficult inquiry with regard to software, and it is an inherent problem with having a one-size-fits-all patent system that was really initially developed for patenting of things like machinery and chemical compounds, and then applying it to this much more intangible product like software.
But does it remain protected under copyright law?
Yes, and copyright is a completely different animal, which we begin looking at next week. There are topics related to software that, despite the general coverage of software by copyright, are not protected by copyright. You'll see that there's a case, SAS versus World Programming Limited, decision out of the Court of Justice of the European Union and a subsequent High Court of England and Wales decision, which makes it clear that the functionality of software is not protected by copyright. In other words, the literal text of the software may be, but if someone is able to emulate the same functions using different coding, then copyright doesn't protect that. And that is an inherent limitation of copyright, and one of the reasons why software developers insist that we actually need patent protection, because patents protect not just against copying, they protect you against people who independently come up with the same idea, and at least in some cases independently come up with a different way to achieve the same thing.
It's Lily here. Just on the discussion on exclusions, I think it was in the textbook that I'd read that the two different approaches, which I think it looks like sort of the European approach is the hardware approach, and then the UK takes more the technical effect approach. But it said in the textbook that the outcomes are generally, the decisions are generally the same. So the European and UK generally end up coming to the same decision, even though the approaches are different. However, it would seem to me that the hardware approach is easier to satisfy than the technical approach. So I just wanted to see what your thoughts were on that, or anyone else's.
I do think that you're right that the any hardware approach is much easier to conceptualize and apply than the technical contribution approach.
Yeah, so I mean, you asked obviously in the question just to give a sort of general overview of the concept of standard essential patents, and I think the way I sort of described them in a nutshell was patents that are held in respect of innovations or inventions that are encapsulated within a standard. So for example, a technology standard such as 3G or 4G, in which case their exploitation is necessary if you want to produce a product or service that is compliant with that standard. So that was sort of in a nutshell what my understanding of SEPs are.
By creating standards, particularly in the IT field, the idea is that all manufacturers should be able to design to the same standard in order to ensure that their products are interoperable. That's considered to be a very good thing economically and technologically. It's the development of common standards that enables you to mix and match different products, which is considered a good thing. So there's a real incentive for manufacturers to manufacture to these voluntary standards. But if somebody then holds a patent on the technology that's embedded in the standard, then without taking some kind of special precautions, you've just handed a huge advantage to the patent owner, who can say, well, you can't manufacture to this standard unless you have a license. The subject of standard essential patents comes up in different ways. Standard setting bodies, they are voluntary associations of technology developers and manufacturers, and they put forward ideas about what the standard should be. It's agreed upon, and that becomes the standard. Well, there have been some cases in which companies that have participated in standard setting have failed to disclose the fact that they hold patents on elements of the technology that they're proposing be included in the standard. And then when the standard is set and people start manufacturing to it, the patent owner pops up and says, pay me or I'll sue you. And that's something that in the notes I think I referred to as patent ambush. But it also comes up in cases where the patent owner has been much more forthright. Most of the technology standard setting organizations have a requirement that if you're going to participate in the setting of a standard, and companies can do this voluntarily, but if you do participate, then we require you to disclose any patents or other intellectual property that you hold that is essential to the implementation of the standard, and that you make a promise to license the technology to anyone who wants it on fair, reasonable, and non-discriminatory terms, or using the acronym FRAND. How specific does FRAND sound to you all? Does that sound like a good basis for licensing?
In respect to standard essential patents, I think it, on the face of it, sounds like a reasonable way of doing it. However, I think, as I mentioned in my note, it's extremely difficult to actually define exactly what that is. And it's very rarely actually stipulated in the context of FRAND undertakings given by the patent holder, which is where the problems arise in terms of injunctions down the line.
It's difficult for a patent owner to say in advance, these are the terms on which I would be willing to license my patent if my technology is incorporated into the standard. FRAND, fair, reasonable, and non-discriminatory, is more or less the standard commitment that is required in these organizations, and you'll see that there is a case where the holder of a standard essential patent disclosed the patent, made the FRAND commitment, Huawei versus ZTE case. The parties couldn't agree afterwards. The manufacturer said it would agree to a license, but they couldn't agree on what was fair and reasonable. Huawei, the patent holder, sued the manufacturer and requested an injunction to prevent it from using its patented technology until they worked out a license. And the question that came up in that case was, is it a breach of competition law for the standard essential patent owner to seek an injunction when it has made a FRAND commitment and when the defendant has said, yeah, I'm willing to take a license? It is a very hot issue right now internationally.
I had one question, Sean. I'm no expert in terms of the functioning of standard setting organizations, but I noticed in some of the case law they seem to refer to either pre-existing or post or court-imposed frameworks for deciding on FRAND terms. Do you know how regularly sort of the larger standard setting organizations tend to have these frameworks for establishing FRAND terms in place? Or is that something relatively new?
Yeah, I don't actually know off the top of my head. I think that what we're seeing in the cases that are currently being decided is usually based upon standard setting organizations' policies that were in effect several years ago. And so the current practice may be different from what we were reading about in the cases.